Well, hi, everybody. I'm so glad you're here. Thanks so much for joining us. I'm Sarah Perkins with Lawyer's Title. I hope you can hear everything all right. Thumbs up if you can. Good, awesome, like it, thank you. So just wanted to say thank you to Francisco for being here with us today. I'm gonna give him an intro, but wanted to also say, it's crazy out there in this market, and real estate is just always just all over the place. And this past 12 months have been insane. And want to just, anytime you want to talk about real estate, love to geek out on the numbers and what's happening. We do have Tina Tambor presenting on Friday. If you haven't seen that link to registration, let me know. She's going to go all through the details of what's happening, really go in depth of the Phoenix market. So we're happy to share that link with you for if you don't have it. So with that, I do want to thank Francisco again. So I met him a couple of years ago. He has an awesome law firm here in Chandler. I know I've met a number of the different attorneys he works with, takes it very seriously. He reaches out, asks title questions all the time, really trying to take care of his clients. And so we've been working together on a number of projects. And so we're really excited that he's put this together. He's got another, part of his focus is education and letting everybody know what their options are. And that's why it's kind of a class that has two separate topics that both are very important in real estate, but don't necessarily have anything to do with each other, but they're both really important. So we really appreciate Francisco being flexible when I'm like, hey, can you teach a class on two separate things? And he put it together for us. So I just want to say thank you so much. And I'm going to hand the floor over to Francisco and make sure you're unmuted. Oh, you're muted.
There we go. I think I'm good.
Awesome. Well, thanks, Francisco.
Cool, man. Thanks for the invite. Appreciate everybody sticking with a lawyer today. You're going to get an hour or so with a lawyer and no bill at the end. So I think that's a good thing. I'm going to share my screen. I actually won't make it the whole hour today just because I have to be in an appointment right at 11 o'clock. And so I'm going to have to make sure I'm off about 5 minutes till. But yeah, Sarah was kind enough to invite me to do this. And when she said, I want you to talk about probate and give us the primer on that, but then LLCs and PLLCs, I'm like, what the heck, So, okay. So I created the title slide. And I hope this fits what you wanted, Sarah. And I hope, actually, I completely tied all this stuff together. I don't think you guys will even notice that this was two completely unrelated topics the way I think it will help. I really hope that you guys walk away with a couple nuggets out of this, that you can just grasp something with your business and also with your family that helps you do a better job. All of us, I own Keystone Law Firm. So I'm a business owner. I've run this business for almost 14 or 15 years now. And like, I'm a lawyer, but oh my gosh, do I have to struggle with the struggles of a business owner, just like the rest of you. And if there's anything that I've learned from owning a business, it's that it 100% affects your personal family life. There is no getting around the fact that what happens at the business is going to affect my wife. It's going to affect my attitude as a dad, how I show up for my kids. And so in all of these areas, like, I just don't see things anymore as in their own separate buckets. It's all part of our life. And so the better we can do with these kinds of things, with all of these things, the better we just show up in every different area of life. So yeah, it's Probate Simplified and how to protect your LLCs and PLLCs, two kind of seemingly separate topics, but it's all really the same thing. Real quick, just a little bit about me. I'm the founder, CEO at Keystone Law Firm. I've been an attorney for about 14 years now, I think. Our firm, we 100% focus on estate planning and estate administration. And so that means we are basically looking at how to protect assets from the threats that are out there, all the different threats that are out there, but with the purpose of protecting it for the people you love, that you care about. not just for the sole sake of protecting it and accumulating masses of wealth, but with the purpose of helping you create the life, helping you give the life that you want to the people that you care about. Our firm, we crossed over the $1 billion mark of assets protected for our clients, and that's pretty fun. It's kind of crazy to think that we have literally put wrappers around $1 billion out there that now can't be touched, by anybody except who our clients want to be able to get to it. I come to you today with a very big confession, and this is really where I want to start. I truly, from the heart of my hearts, I believe lawyers have completely destroyed the system. I think there probably was a time in history where lawyers were always seen, or maybe mostly seen, as the solution, as helping people navigate and plan and do better. And so much so in recent years, I don't know when the tide shifted, that I think the system has now been built by lawyers in a way that is just sometimes feels impossible to navigate. And sometimes it just totally feels like it's set up for lawyers to be the only ones who can figure it out. I heard somebody say, having lawyers draft the laws would be like having doctors design the diseases, and in a way it just is. I mean, especially in my industry, where if you don't get the planning done right, it's the lawyers who are going to win. Really, the lawyers are going to end up with the money. And that's just so messed up for me. To me, it feels like if we don't do anything, if we just go under the default rules, it seems like the default rules should set up the families to win. But the default rules currently are set up for the lawyers to win. And so that's what I want to completely help you guys figure out how to get around that. The big thing for today is what is probate and how to protect your family from that. There's really two big things in probate, okay? And if you walk away with nothing else except this concept, this will be a big win. There's two big things in probate. There's the probate that happens after we die. Yeah, that happens. That is there. That's the one everybody knows about. People, sometimes it's not so bad, and sometimes it's a big, ugly fight. What a lot of people don't know about is that there's this probate lurking out there that happens while people are alive. And in Arizona, we are known across the country as one of the worst living probate states in the country. Our living probate process is insane, and it is triggered. It's mandatory if you don't have all these legal ducks in a row, okay? When somebody is incapacitated, right? Alzheimer's or dementia, or there's a stroke or a car accident, there's some type of emergency, and they're incapacitated, that triggers a whole bunch of things, right? And this even happens in married couples. We have a client who they've been married like 30 years, and her husband was kind of young when they first discovered he had dementia, and I think it was in his early 50s they discovered this. It wasn't too bad, it was mild, but it was vascular dementia. They could see this was going to happen, over the course of time. And so they got all their, trust and will and everything in place. He kept working. I think he worked about another 8 or 9 years, and then it got to a point where he just had to retire. And thankfully, he was a pretty successful businessman. He's actually responsible for some of the technology we all use every day. His company helped develop some of that. And so they had a nice, chunk of change stuck away in their nest egg. Well, it got to the point where he couldn't manage anything anymore. She needed to be in charge of everything. So she took their will, their trust, their power of attorneys, started going around to all the banks, all the investment companies, their financial advisor, everybody saying, you've got to take him off, because if he still has access to this account, he's going to get taken advantage of on the phone. Someone's going to call and he's going to give away our account numbers. So she had to take him off the accounts. And she got to their financial advisor, and he sent the will or the trust, the power of attorney, up to their compliance department, and came back rejected. And he's got the letter and he's going over this letter with her. And he's like, what? Like they're looking at it. It's like, sorry, we can't honor, the trust, power of attorney. We need her to go get something called letters of conservatorship. And so he calls the compliance department. He's like, what the heck? And they said, well, the power of attorney is like 10 years old. We can't recognize that. The trust was never implemented all the way. So it doesn't even control the situation. So the only thing she can do now is go get letters of conservatorship. Well, both of them are like, what are those? Where do I get those? And the financial advisor knew me, referred her to me. I had to explain to her that's a living probate. And guess what that means? That means now we have to sue your husband and get a court order that says you can access that account, because that account is now frozen by that institution. So that institution, right? They heard he was incapacitated. They froze the account. They won't release funds until she gets a court order. That process is insanely expensive. That living probate process cost her about $50,000 in legal fees to get it set up. And it's about $10,000 per year for her to stay in compliance. It's a nightmare. And this is not uncommon in Arizona. If you have old documents, they're not kept up to date, if they weren't implemented correctly, then that's the risk, is this big, giant, expensive probate. We had another one where a husband, his wife had dementia, just wanted to downsize, just wanted to sell the house. And, he's going to move into a smaller house because she's going to a care facility. He gets the house under contract, goes to close, wasn't with lawyer's title, but then the title company says, we need a signature from your wife. This house is owned jointly. And he's like, well, she's incapacitated. Let me dig up the power of attorney. He digs up the power of attorney. All he can find is a photocopy, but it's there. It's valid. I could even look at it and say it's valid, but it's a photocopy. The title company says, man, we can't recognize a photocopy. We need an original. Couldn't find the original. Couldn't close on the property. The only option he had was to go get that court order from the living probate system that would allow him to sell this property. And then once you do that, now your spouse is a ward of the state and you have to account for everything to the court system every year. He ended up deciding, like, screw it, I'm just not going to sell. And he just stayed. He needed the money out of that house, but it was going to be tens of thousands of dollars to get the court order. And he thought, as bad as it is to think this, he thought, my wife might die in 6 months, and that's just easier. And I didn't necessarily blame him to think that. Living probate, it's a nightmare. It's the worst in the country here in Arizona. So avoiding that is critical. After death, right? It's not as bad as that, right? In Arizona, the probates after death, it's still a nightmare. It's still something to be avoided. I don't recommend you use that if you don't have to. The typical average fee on a living probate is about $50,000 in all the probate fees. And that goes to the lawyers. And then after death, the typical fee is about $20,000. And these are for averages, right? Now, the reason I've got a heart and a dollar sign there is because probate is also intended to deal with the care of a person, right? So if a person can't make decisions on their own and they don't have an updated healthcare directive, mental health power of attorney, living will, I'm going to go over these in just a second, then the court system is set up to do that. It's set up to appoint someone to be able to make those decisions for you. So it deals with the care, the health stuff, but also the finances. Last time I looked at the numbers, our court systems in Arizona, they publish their statistics. And last time I looked, we have 14,000 families every year going into probate. And if you think about the average numbers, I didn't do the math, but let me just do the math real quick. 14,000 times 20,000. That's $280 million per year going to lawyers. $280 million. Holy cow, right? Totally avoidable. You do not have to do this. You do not have to opt into that system. You can opt out of it. What I want to show you now is the basic fundamental documents that I recommend everybody have. And I just 100% believe that everybody should do this, regardless of how complicated. Most people's situation isn't complicated. So regardless of how simple your situation is, the reality is that in order to keep it simple, these are the tools you need. So I'm going to show you about 10 or 12 different documents. So what I've got on the left there, we created a plan for Homer and Marge Simpson. That's the kind of the cover sheet. Your trust, your estate plan is a whole bunch of different legal documents, okay? Your trust is not just, I mean, it is just the trust, but then there's also all these other documents. So here, the first three is a living trust. So they've got the Homer and Marge Simpson trust agreement, but then you also need wills, each of them. A married couple can typically have a joint trust if it's not a blended family. And then they each will still have their own will. All of your wishes are going to go in the trust, though. The will is going to be pretty plain. There's not much specific in there, okay? On the financial side during life, you each would have a durable power of attorney. And we don't record these right up front, even though it's got the little recording symbol in there. We set it up that way so it can be recorded later if needed. But each spouse gets one of these. These are only to manage financial things and pay bills if you're incapacitated. Okay, you designate who it is. Usually spouses designate each other. Then you name some backups. On the medical side, on the health stuff, you need at least these three. Okay, your healthcare and mental health care power of attorney, your living will, and an authorization. The first one up there, what that one does is it says who is going to make the decisions for you. Who are you putting in the trusted position of making decisions? And it's two kinds of decisions. It's not just, it is the end of life decision, okay? But it's also the long-term care decision. You know, I mean, what's going to happen if you get Alzheimer's and you need someone to just be making decisions month after month after month after year after year after year? The one gal I told you about who had to take care of her husband, it's going on 12, I think it's going on 13 years now. That's not uncommon for it to just go year after year after year. So that first one is where you're going to name who has the power to do that, right? Who do you trust? And typically it's going to be your spouse first, but then after that, you need a backup. The second document is your living will. What is your living will going to say? That's going to be where you want your decisions. Like, am I going to be, pull the plug kind of a thing? Do you want that decision made? If you're on artificial life support, the doctors can't do anything more except keep you physically alive, but you're in what's called a persistent vegetative state. That second document, it says, go ahead, pull the plug. I don't want to be here. Okay, that's what that second document says. And then the third one is, we refer to that as the HIPAA release. It is your, HIPAA, kind of heard this. It's across the country. It's a federal law that says your medical information is private. It's confidential. Nobody's allowed to access that except you and your medical professionals. Okay. So if that's true, imagine there's an emergency. You're driving to work or you're driving home and you get in a car accident. You're unconscious. They take you to the hospital. If you don't have some written permission that says somebody's allowed to call the hospital and say, hey, what room is mom or dad in? The hospital is obligated to not disclose who their patients are, right? I mean, we don't want them to. I don't want to call the hospital and say, hey, I want to find out if my worst enemy is in the hospital. They should not release that information. So they have to say, I'm sorry, we can't say who may or may not be a patient of ours unless you're on the approved list. Well, if you're unconscious, you can't create an approved list. And the only way to do that is for the family then to go to the court and get an order saying, hey, can we please get an order releasing their information? This simple document just creates that list ahead of time. Put anybody you want on there, right? We have clients who put their, not just their family members, but even like their pastor and a best friend or whatever. You can put whoever you want on there. But those three documents are the key to avoiding that living probate for the health purposes. The prior documents, the trust and the power of attorney, are the key to avoiding the living probate for financial and money purposes. So with just those 5 documents or 6 documents, you completely avoid the living probate nightmare. Okay. Okay, now we switch gears a little bit. whenever you're setting up a trust, and it's the same concept with an LLC or PLLC, you create the entity, right? You create the bucket. You create that thing with the new name. It's not you anymore. It's now this alternate ID. Okay, you got to put stuff in it. You have to put stuff in it, and that's what this is. This list is just it's what we give all of our clients. It says, hey, with your bank accounts, you need to do this because you got to put bank accounts in your trust. With your investment accounts, with your retirement accounts, with your real estate, with your vehicles, with your stocks, your bonds, your mutual funds, everything listed there, you got to do something. You got to tell that company that you now have a trust. Here's my trust. Please register this trust on my account, because that's how it makes it easy, right? If you're, same thing with your LLC. If you form an LLC and don't put the bank account in the LLC name, your LLC can't use that bank account. It has to be in the name of the LLC. The next thing that we do for our clients is not just the generic list, is we actually give them an item by item by item list of their own specific accounts, investments, assets, real estate, business entities, whatever, everything, and specifically how it needs to be registered. Because the title is everything, right, Sarah? I mean, title is everything. If it's not on the title, you can't sign. And that's what the trust funding step is all about. And then sometimes we also give our clients these specific instructions, but the bottom right there is the thing that I really want to flag for you guys, which is the how to register those accounts in the name of a trust, right? The husband and wife trust agreement dated whatever. So if you're like this example right there is for an insurance policy. So on life insurance, what I recommend clients do is like even myself, right? I have a term life insurance policy. I die, my wife's going to get a bunch of money, except on my life insurance policy itself, I actually name our trust as the primary beneficiary. And that's kind of the way it's designated. So the primary beneficiary is our trust agreement. The secondary beneficiary I have as my wife individually. So first it goes to the trust, then it goes to my wife individually. And so with different types of accounts, different types of insurance, you might have different orders of that recommendation, but that's the style of how the trust name is used on those things. All right, so that's probate, and that's kind of how to avoid probate. What about your businesses? So let me show you something that it was a decade of practicing before somebody finally shared this concept with me. And I'm just putting my own spin on it. Who has seen this movie, Inside Out? If you have little kids, you've probably seen this movie. I love it. It's a great movie. Like, I mean, it really gives you this framework to be like, oh my gosh, there's little people in my head that are fighting against my success. And anyway, the girl in the movie gets them all lined up to finally be working for her. Inside Out, though, is the concept, okay? So here we've got 3 circles. Think of these as totally 3 separate entities, okay? You've got your middle one, which is yourself and your living trust, okay? Then you've got your LLC, maybe number 1, maybe you've got 10 of them over here. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay, you've got different LLCs. Maybe you've got a professional LLC over here, or maybe you got multiples of them. Fine. Think of each of those as separate little islands. And then the whole idea of asset protection is boiled down to this inside out concept. Whatever's inside each entity, okay, the positives and the negatives, the money and the debts, the assets and the liabilities, whatever's inside each entity, you want it to stay in that entity. You don't want what's inside getting out, okay? You don't want what's inside your entity getting out. Okay, you want to be able to keep it in there and lock it in. Now, if you have your that middle circle, your personal assets, including your living trust, because those are always part of the same bubble, and you have a massive liability. Let's say you're just driving to the grocery store and you accidentally hit someone and you kill them, right? It's a wrongful death lawsuit. They're going to come after you for millions. We had terrible, terrible story of our sister company does financial planning. The owner of that company, his friend was picking somebody up at Sky Harbor. And you guys have all done this where, you're pulling up to the curb and it's like millions of cars pulling in and out and trying to get up to the curb to pick up or drop somebody off. He goes to pick somebody up to park, and he pulls up behind a car, and instead of, I don't know what happened, but instead of hitting the brakes, he hit the gas and hit the car in front of him, right? Hit the bumper, because you're like 3 feet apart. Which wouldn't have been a big deal if it not were for the fact that somebody was standing there unloading their luggage, and he crushed the guy's legs and basically crippled him for life. The guy he hit was like a 35-year-old brand new cardiovascular surgeon. The dude had millions of dollars of lifetime earning potential that was lost in a moment. He had a couple kids, he was married. No question of liability. This guy who hit him was going, there's no defense, right? Thankfully, he had a very solid umbrella insurance policy that was able to just literally flush the toilet and pay 100% of it over to this guy and his family. And they accepted and settled for that amount. So it didn't destroy him financially. But these things happen, right? They just happen, and they're an accident. And so if you're in your bubble and something happens, you want that liability to be resolved within that bubble. You don't want it going out and getting your LLC number 1 assets, okay? You want what's inside to not get out. Now, by the same token, if you have something in your LLC that happens, right? You own a bunch of rental properties, and somebody drowns on in one of the pools, and they figure out how to hire a lawyer to sue you for liability, right? You don't want that liability, that outside liability, getting into your personal bubble. You don't want that outside to come in. And that's the truth of how asset protection works, okay? It's the concept of creating separate buckets and then maintaining and managing them so that that nothing can pierce the corporate veil. You all have heard that term. So it stays in its own little bucket. Now, how do you wrap that into your estate plan? So the way you wrap it into your estate plan is you basically create your trust as the top level entity that owns the membership interest of any of those entities that you have, right? Your LLCs, PLLCs, if you have partnerships, the trust owns those entities, right? You do that with an assignment. There's 2 things to know about that, though. You don't ever want to, with an LLC, you can assign that interest to your trust, and you can register that with the Corporation Commission. If you have a professional limited liability company, usually you can assign it and keep that assignment privately within your own records, but you have to do 2 things. I don't recommend you re-register the entity ownership, but then more importantly, in your trust, you need to have some language that says, hey, if something happens to me, because I'm the licensed professional, if my trustee, like my spouse, my wife's not a licensed attorney, if something happens to me and she takes over my trust, she must appoint a special trustee who is licensed to manage and wind down my business, or transfer it or sell it or whatever they need to do. But that PLLC, that professional license, just has to be designated by your trustee in order to manage it. And that works for most industries. Some industries allow a non-licensed person to own it, but most of them are going to have some restrictions around that. And so your trust just needs to say that you appoint a special trustee for that purpose. Now, with LLCs though, and PLLCs, same thing applies. There is a very little known tool you can use. When you create an LLC, you say, I'm the owner, or me and my partner are the owners, or whatever, we're the members. Generally, you jump on the Corporation Commission website, people now just form them right there, file it, and it's done. Well, if something happens to one of the owners and you can't sign anymore, right? There's an emergency, medical emergency, or you die. Your ownership interest is like a stock certificate. Nobody can transfer that unless they have the legal authority to sign on your behalf. Okay. Ninja secret is that in Arizona, you're allowed to actually designate a beneficiary on your ownership interest in an LLC, just like you would a life insurance policy. So you can literally say, hey, on my death, it goes to my spouse. On my death, primary beneficiary, secondary goes to my kids or whatever. You can say, designate beneficiaries just like life insurance on your LLC. There's no standard form for it, but you can do that. And then boom, there's no probate required. Now, it doesn't take care of what happens if you become incapacitated, but it at least deals with what happens after you pass away. Okay. I feel like I'm going way too fast, but I want to make sure I get all this in. Here's the deal. What I probably in my time, I've probably, I don't know, maybe 4,000 to 5,000 families is the number of families that I've done consultations with. And out of those, probably about anywhere from 1,500 to 2,000 have actually put their plan together. One of the biggest reasons I've discovered, and most of this discovery comes from working with families after the fact, after somebody has died and they're in a mess. And I'm having these conversations with them about like, why didn't they get this done? What happened? And they're, the adult kids are saying things like, they kept talking about it. They wanted to do it. They kept talking about it. They wanted to do it. And even like, I kept trying to get them to do it. I kept telling them, Mom, Dad, get your trust done. Come on, Dad, get this done. Mom, get this done. And it just wasn't getting done. And what I've really discovered is that a lot of people don't do this because it's overwhelming. It just feels daunting. It just feels like it's too hard. And I 100% blame my industry on that. I 100% blame lawyers and estate planning professionals on the feeling that you guys have, that people out there in general have from doing this. It is not complicated. It is crazy, crazy simple. And I'm going to show you guys with a quick little exercise how simple it actually is. This is the process we go through. It's 5 steps. Our firm either does this all with our clients one-on-one, very white glove concierge. We're a very boutique estate planning firm. And so when we work with clients one-on-one through all of these steps, no matter what the size of the estate is, it's a lot of an investment on your part for your time and your money, but it makes it simple for you because we're guiding you through. Some of our clients are like, nope, I want to do as much as I can. And so we have a lot less involvement, but we still get it done. The biggest tool that I think, the best tool that I think I've created in all these years is this. And this is the exercise. Okay. I don't know how many people we have on here, 19, 20, something like that. You're all here. You've all blocked this hour, and I'm going to take 2 minutes right now to have you walk through a personal exercise. And actually, I'm going to open the screen up because I want to watch all of you as you either do or don't do this. So I can call you out. I'm not going to call you out by name, but I will blame you if you don't do this. All right, here's the deal. You've all got paper somewhere and pen in front of you. I want you to take a minute, just chill out, right? Talking to the lawyer about death and taxes does not mean it's going to happen. All right, on your piece of paper, or no, not on your piece of paper yet. You've got paper in front of you. Put your pen down. We're going to take a minute and not write anything. What I want you to do is feel how easy this actually is. Lawyers haven't yet realized that there are these really amazing things that are called computers that have templates on them so that we actually don't have to rewrite everything every time we need to make a change for a client. It's amazing. I've discovered it. And so we have this huge advantage over every other law firm out there. And so I just want to share with you guys how easy it is for us to make changes when a client has something they want to change. You know what that means? It means that what you put down in writing the first time doesn't have to be the last version. And I think it never should have been planned to be the last version. Okay. So here's how you make your first version. Everybody close your eyes. I usually do this in person, and people get all freaked out about closing their eyes when they're sitting in a room with a lawyer. But you guys are safe. You're home. Close your eyes. All right. I want you to just let your mind wander for just a minute. Imagine yourself getting up. We finished this webinar. You're going to get up, and wherever you're going to head out to next in the world, you go grab the car keys, jingle, jingle, jingle. You walk out to the car, open the door, click, click, start the engine, vroom, vroom, snap your seatbelt, click, and you pull out onto the road. You start driving, and you're headed off. It's a beautiful, sunny day in Arizona, and then bam. And that's it. You don't have one more second to express or say or think about anything. Okay, open your eyes. If somehow I had a crystal ball and you knew with absolute certainty that you literally had 30 minutes left on this earth, you had 30 minutes left. If you knew that that was true, could you put down on writing these three things? Who gets your stuff? Who's in charge of distributing your stuff? And who makes that ultimate decision to pull the plug? If you knew you literally had 30 minutes left, could you put those in writing? And doing this over Zoom is a lot harder than in person, because I would literally be looking at every single one of you eyeball to eyeball. And until I get a room full of heads going, yep, I call you out and I say, why not? You've got 30 minutes left. I guarantee you can make a better decision than what some judge would make. And that is truly what I recommend you put in writing. Get that done. If you have an old plan from 5-10 years ago, guarantee there's laws in there that are outdated. There's probably stuff in your life that has changed. Getting something done in writing that fits today and is legal and is binding. And the big secret is that it can be changed easily, right? It can be changed super easily. Getting that done is more important than waiting 10 years to get it under this fictional thing called perfect. Nothing is set in stone. That's what we recommend you do. I recommend you get something done. And then you know what? Thank God, you're probably going to live beyond today, beyond this first version. And a year from now, 2 years from now, you just do the mental check-in. Wait a minute, I made those decisions. Does that still fit? I've thought about it a few more times. I actually do want to make a change. And what I've discovered is that clients who get something done, even if it's not quite in that like it's perfect mode, getting it done resolves the 90% that they know is right and lets their mind only focus on that other 10% or whatever, that little bit that they really feel like they want to mull over for a year. Fine, mull over it. Your brain will give you a solution at some point. Either I'm good with that, or, oh, here's what I want to do. Let's make that change. And then you make that change. And then keeping those things checked in on once a year. I recommend doing an annual checkup on this stuff, just like you do with your doctor. You get your car maintained. Laws just change so rapidly. And especially this year with the new White House, we're getting proposals on massive, massive estate planning tax changes, massive, massive capital gains tax changes. And so there's going to be strategies that have to be changed that were good, last year that aren't going to be good by the end of this year. And that just happens so darn frequently that it's worth an annual checkup on this stuff anyway. So that's what the 3-minute decision matrix is for. It's there so that we can focus really, what do we need to get accomplished here today? You don't need to figure out what the plan is going to be in 5 years or 10 years or 50 years. You just got to have a plan that fits today. I guarantee you, if today you get a plan that fits, that you're designing around a situation that's hypothetically going to exist in 10 years, it's probably not going to fit that well today. And then if something happens to you today, you've got a plan that doesn't even work. So make it work today. Doesn't have to be harder than that. All right, I am wrapping up. Good. And I put together a little gift for you guys. Since this is all we do, we've just got tons of resources. And so I thought, what would be cool? I don't know, like here's 3 things that I thought would be useful. And so Sarah, I'm going to give this to whoever wants it. We have a graphic that sort of explains how the trust plan flows, right? Stage by stage. We have one for married couples. We have one for single people, through somebody's incapacity, through the first death, through the second death. And then if things are forgotten, what happens in probate. That middle one there is a family affairs checkup. It's really simple. I think it's 12 questions to kind of check off my medical stuff, my financial stuff, and my estate stuff. Is it all up to date? And then something we get asked a lot about is what's the difference between a will and a trust. So we put together the brochure on that. And if anybody wants that, just shoot my staff a text message and we will send it out by email. Easy peasy PDF document that you'll get there. That's all I had, Sarah. I went a little bit faster. So I guess we have a couple minutes for questions if you see any questions.
Well, we do have, I'm already getting messages. People want this. So thanks. That's awesome. The info. So thanks so much for sharing that. And we have had a couple questions and, and if people want to, we have a nice group that if people want to unmute themselves and ask, we can do that. Or I know we just have a few minutes and
let's do it by chat just to make sure we get the questions answered. One of the things the State Bar hates is if lawyers start doing group questions, because then I'm like, well, let me answer it. So also tell me about this. Tell me about your family affairs. Tell me about your private financial matters. And then it's like, wait a minute, I don't want to give all that. So let's do chat, send in questions. Post it in the chat, and I'm happy to answer anything, guys. I mean, they're all hypothetical, and it's not legal advice. It's just good information. So yeah, feel free to send chat messages in right now. I've got about 10 more minutes, and we can.
So before because we had one question that came in before these others, and it's, should somebody, or advice was given to not put a house in a trust. Is there a reason to not put your property in the trust versus to put it in the trust?
There is one specific strategy that is aimed at one very unique circumstance when you can't put it in a trust, in a regular trust. Okay, there are different kinds of trust. And what I've been talking about today here is a revocable living trust. So there's one strategy out there that completely falls apart if you put it into a revocable living trust. And it is getting a elderly parent qualified for Medicaid benefits. So if somebody has to go into a nursing home, it's super expensive. Right now, I think the average in Maricopa County is about $7,000, $8,000 a month. If you don't want to just bleed all their money down, you can protect their assets and get them qualified for Medicaid. Well, some people have their house or put it into a living trust. When you do that, Medicaid says you don't qualify. So because your house is in a trust, it's a really dumb rule that they still have, but it's just a rule that exists. So if somebody needs to go into Medicaid, you actually want the house in their individual name. And then there's some other strategies to keep that house exempt. But other than that, there's not really any downsides to having it in a trust. You still get the 121 exclusion when you sell it. You still get, under current law, a step up in basis on the value of the house when you pass away. You can sell, you can buy. It's pretty straightforward. Sometimes there's a wrinkle with mortgage companies. They hate seeing homes in trusts when they have to do a refi. And so they'll pull it out of the trust. They'll do the refinance. You just have to remember to put it back in the trust, because a lot of times they won't do that for you. But no, I mean, there's really no downsides to the revocable living trust.
Awesome. Okay, thank you.
Yeah.
We've had a couple more questions that came in Francisco, I hope you can see them on the side with the chat too, but
yeah,
the role of beneficiary deeds, I can answer at least in title. Beneficiary deeds don't expire as long as there's not a deed that's been recorded after it.
Yeah, right. Beneficiary deeds are great. We use them a lot. It's a really simple way to avoid probate at death. It does not avoid probate during life. So we see this a lot. Married couples will own it joint with right of survivorship or community property with right of survivorship. One of them becomes incapacitated, Alzheimer's, dementia. The other one tries to sell. If they don't have a current valid power of attorney that's, recent, then they might have a hard time selling that, right? Signing on behalf of their spouse, because they both have to sign that deed or that transfer. And a beneficiary deed only kicks in at death, right? So, and that's everything with respect to anything you have a beneficiary on, right? IRAs, life insurance, those sound like and feel like, no, I've named my daughter as the beneficiary. So if something happens to me in the hospital, she can get to it, right? It's like, nope, you're not dead yet. So beneficiary just means at death.
Perfect. They've had a few people are asking about documents expiring, and you mentioned, documents expiring, and kind of want a little more elaboration on that.
This is sort of the bane of my existence these days is, trying to figure out when documents expire. So under Arizona law, there's no set date for when these kinds of documents actually expire. There's no law. But in practice, here's what happens. Somebody goes to use a power of attorney that's 10 years old, and the company they're giving it to, the bank they're giving it to, is like, you're walking in here, you're not our customer, and you're trying to take all of their money and move it. Woo! Because under Arizona law, there's no law that requires the bank to honor that, even if it still complies with all of the power of attorney laws. So the bank or any institution has their own internal policies on when they will honor that. And a few years ago, and then I gave up. This was maybe 10 years ago. I called around all the banks. I'm like, what's your policy? What's your policy? How old is too old? How often does it need to be updated? And I was getting answers anywhere from it needs to be updated every 120 days. All the way to we don't ever honor a power of attorney if it was not signed on our internal form. And I'm like, are you crazy? The longest time was 120 days. So I basically said, screw all of you. I can't follow your guidance. And so that's when we just really started recommending a trust, because a trust, even if it's old, as long as the asset is owned by the trust, no problem. Like, I have not run into any problems with the successor trustee being able to deal with it. So that's I wish Arizona had some better laws around this, but it just doesn't. And so the way around it is to use a trust.
That was great, because I can second that on the title side. Everything that he just said. Yeah, because we get some of these powers of attorney that are pretty old, and and like Francisco said, we always send them to title. Sometimes they approve them, sometimes they don't, and it's above my pay grade as to why.
Right. Yeah. And we just kind of have to, like, okay, we're not going to change all the million different companies' policies that we do business with, like, I'm not going to go to Bank of America and convince them to do anything differently. So we just got to adapt to it. And the tool is the trust. I mean, you probably see it, Sarah, like if a house is owned in a trust, even if the trust is dated 1989, as long as there's a current trustee that's got the right documentation, they can sell, no problem.
Absolutely.
Yeah.
The trickiest one we had was a trust from 1935, and no one was still alive.
Whoa. But even that, like, you can go to court, get someone appointed, and then boom, they can take care of business. So I see the chat coming in. My recommendation, what we do with our clients is we say once a year, a quick checkup. We do a quick phone call. We've got so the checklist that is on here on this thing, is 12 points, because that's just something we give kind of as a do-it-yourself. Our internal checklist is 31 points. And we just kind of go, okay, rapid fire. Anything changed on this. And because we know the client's situation, if it's like yeah, that's changed, we look real quick. Okay, does that affect anything? And I'd say about 60% of the time we go through the checklist and nothing needs to change. And then 40% of the time, something's like, oh yeah, we need to change that. And honestly, in that 40%, it's only about 10% or like a quarter of those that the client knew they needed to make a change. The other 30% of that is, we discover it. But even if there's no change necessary, what is really powerful about that, what we've discovered, is that if we do it once a year, the longest time that it will have been since you've had that review is 12 months, right? So you do that review. If an emergency happens 9 months later, your family, your loved ones, whoever it is, can see and call us and say, what's going on? We can say, oh my gosh, we knew what the situation was 9 months ago, at least. And we can stand behind these documents and verify they're all up to date, they're all legit, they're all valid, everything's current, and we can sort of be the weight behind making sure they get honored. So we just put a pattern in of doing it once a year. It kind of makes it simple. What time frame? How much? Our costs are all over. We have a whole big range, just so you guys know. We have a DIY service that's at $300. We have our concierge services, kind of the flat fee package, pre-packaged services that we have end at about $8,000. If it's more complicated than that, it's a custom quote. We do a free initial consultation. So, no big investment there. What are the other questions? I think that's it. Anybody else have any questions? Drop it in the chat. Great shit. Yeah. Yeah, it sucks. It sucks that this is even necessary. My next goal in life is to start lobbying the government to just change these laws, and we'll see if I get the time to do that. But yeah, thank you guys. Any questions, feel free to drop it in the chat there. Feel free to reach out to Sarah, of course, and she'll forward it to me. If you text that number, we'll email you that resource. And you can also just say in that same text, hey, I want to consult. We'd be happy to get it set up. Any other questions?
Awesome. Well, we really appreciate your time, Francisco, and explaining some stuff that is super confusing. So, keeping that clean, we appreciate it, because it's hard to make sense of all of it. And I know there's a lot of different advice floating around. So thank you very much.
I get it. You guys, my pleasure. And thanks for having me, Sarah. Thanks for being here, everybody. Everyone have a good day. Stay safe, and look forward to seeing some of you soon.
Sounds good. Thank you.